190, Bordeleau versus State of New York. Counsel.
May it please the Court, Barbara Underwood for the State and State-related appellants. I'd like to reserve 2 minutes for rebuttal.
Sure. Go ahead, Counsel.
Plaintiff's sweeping challenge to the practice of making economic development grants fails for 2 reasons. First, when a public authority transfers money to a private corporation, it can't be a prohibited gift of state money because money in the hands of the public authority is not the money of the state. And second, when the state transfers money to a private corporation to pay for actions, for services that benefit the state, that's not a gift prohibited by the Constitution. It's a grant or a contract, money paid for services rendered.
On your first point, are you saying it's okay for the state to give money to ESDC where the ESDC is expected and required to give it to me or you?
Yeah.
Isn't that?
Well, the question whether ESDC can be properly required to give it to me or you turns not on the gift clause of the Constitution, because the authority isn't bound by that. It may turn on.
You're not saying okay is too broad, but you're saying that's not a violation of the gift or loan or credit clause.
That's correct.
Doesn't that just invite evasion? All you've got to do is put an intermediary between the state and the recipient?
Well, this Court has the Constitution in 1938 in recognizing the separate character of public authorities, and this Court
You're not absolutely answering my question. Does it not invite evasion?
I don't believe it's evasion. I believe it's an arrangement that the Constitution and the decisions of this Court have authorized.
Okay, but it's you object to the word evasion,
yes.
But it's a pretty easy arrangement. It is a clause. It becomes a clause not difficult to comply with on your reading.
It's somewhat why public authorities were created, wasn't it, to be able to bond separately so you don't get into the state credit?
That's exactly
issue of
that's
the
exactly
Constitution?
correct. This Court has repeatedly said that authorities don't have to follow the bidding procedures for state agencies. They can their money.
But that's because the state's credit is not on the line.
That's correct.
We're talking about something different when we say that the authority is an intermediary, and its only function is to pass on money from the state to the recipient.
Well, first of all, it's not its only function, because in fact the authority has a program. The money has to be consistent with the program, even when the legislature directs it. If the legislature directed the authority to do something that wasn't within the authority's program, it would return to the legislature. There would be discussions about how to solve that problem, because it would be inconsistent with not the gift clause, but with the authority's governing structure.
So
it's also.
What about the directly versus indirectly idea? Why isn't it the plain meaning of language? Why isn't it that all of these different things are in one way or another? And again, I understand this case law that's interpreted a lot of this, but why isn't it doing indirectly what you can't do directly in the broadest sense of just common sense?
It may be that in the broadest sense of common sense that it is doing indirectly what can't be done directly, but that is what authorities were designed to do. And the 2 cases cited by the appellate division.
So you would say indirectly may be okay?
It may be okay if it is otherwise separately authorized.
This is not a new practice, is it?
No, it is not. If I could just finish the thought I had before.
Go ahead.
The 2 cases cited by the appellate division for that proposition, that the state can't do indirectly what it can do directly, Wien II and Schultz ultimately upheld the action of the authority and rejected the claim.
Now, what do you think the rule was in those cases? What were they saying?
Well, what they said was essentially that the authorities were created with particular powers, and if it comes to pass, well, actually what they said was the presumption of constitution. The reason on the one hand, the state can't do indirectly what it can do directly. That's a general principle. But on the other hand, there's a presumption of constitutionality. We have to have special deference to state funding programs essential to addressing the problems of modern life. And, said Judge Kaye in Schultz, the importance of respecting consistent precedents on which decades of commercial transactions have been premised. So we have this arrangement.
All of those sound like a reason. Sounds like you're completely negating the general proposition. You're saying you can do directly what you can do. You can do indirectly what you can't do directly, as long as you've been doing it for a long time and you're the state.
And the Constitution and the laws and the precedents of this state have authorized it.
Where's the line? Is the line just that we've been doing this a long time and that, you know, it's good for the state to be able to do this, promotes economic development, whatever the goals are? What's the line to be drawn? You know, this is, there are a lot of cases in this area, and you're right. In a lot of them, the courts determine, well, even though this is a general proposition, it's okay to do it. Where's the line? How do we determine in a case whether it is violating the Constitution and giving public monies
Well, I
to
would
private?
say there's one line, Judge Lippman. I think the point of all these cases is that money in the hands of an authority is not state money. So the Constitution.
So anything goes in money?
Well, not anything goes.
What does go?
Whatever the rules are that relate to what authorities can do is what goes.
There's no test that you're proposing? I mean, some of the cases talk about a dominant public purpose. Is that the appropriate test, or do you propose something else?
No, the authorities actually each have a public purpose. That's part of the constraint. The authorities have to be created by statute, and they have a purpose, and their actions and their dispositions.
What's the answer to Judge Graffia's question? Does it boil down to, I guess that's what we're trying to ask you, does it boil down to a dominant public purpose? Is that sort of a common denominator in all these situations?
I would say that's part of it. It has to be actually the public purpose of the particular authority, not just any old public purpose.
So it has to be, as long as it's consistent with the authority's public purpose, it's okay?
Well, I suppose if there were race discrimination, I mean, one could imagine other things that might make it not okay.
We're
but
talking about the gift and loan.
The gift clause, I think the simple answer is that the gift and loan clause does not apply to the authorities. That is not the only.
It is impossible for anything the authorities do to violate that clause.
Yes, they could do other things. They could violate other statutes.
And if we should disagree with you on that, I'm sorry, I shouldn't interrupt you. Go ahead. I'm going to ask you to tell me in a minute if we disagree with you on that. What's your other reason? But
yes.
But continue what you were saying.
Yes. What I wanted to say was that the appellate division, I think, in citing Westchester Bank for the proposition that the state can't do indirectly what it might do directly, was misled, I think, by language that was applied to a very different context. In that case, the Court said that giving bond proceeds to a railroad should be treated the same as giving the bonds themselves. But that's not because the Court was piercing some veil about.
Didn't we also say in People v. Westchester County, and I realize this doesn't speak to your authority point, but as a general proposition, we did say public purpose isn't enough. You've still got the gift and loan.
Yes, there wasn't an authority involved there. If we don't have an authority, then we have to turn to the other question.
And in fact, you don't have an authority on every one of these in this case.
No, we have an authority in all of them except the Agriculture Department ones. Almost all of the cases came through the what is by statute the UDC, but it does business as the Empire State Development.
How does the Agriculture Department differ? How does that fit into this puzzle?
Well, that does not have the Agriculture Department is bound by the gift clause. And so what I would say about the Agriculture Department grants, which is also true about the authority grants, but particularly about the Agriculture Department grants, is that they're not gifts because they were made in exchange for the recipient's performance of specific tasks of value to the state. The agreement.
That's the adequate consideration?
Yes.
We're at the pre-pleading stage here, right? I mean, you haven't even filed an answer.
Correct.
And there's a lot of discussion and about the way these things go. And agriculture brings up a good point, where all of the people who don't benefit from these grants, so that if you got Farmer A, who's got his winery, and Farmer B, who's got his, and they say, well, we like Farmer A, so we're going to give Farmer A all of this money to develop his winery because we think that spurs economic development. Farmer B gets upset. He says that's nothing but a gift of my tax dollars to my competitor.
There are no grants here to Farmer A or to Farmer B. They are to the Wine and Grape Foundation, the Wine Council, and the Apple Association.
Shouldn't we then look into that and see, in other words, you may be right, but at this stage of the game, and everything you say may be right, shouldn't the record be fuller before we decide that the state can decide to take taxpayer money and give it to certain private individuals as opposed to other private individuals, whether it's through an IDA or a foundation or anything else?
Well, no, for a couple of reasons. First of all, plaintiff's challenge is not to particular grants. He's not saying he's not saying the state paid too much for economic development in this particular case. He's claiming he's challenging the whole practice of making grants for economic development. He's claiming
Isn't that what Judge Cardozo said in his dissent in Westchester, that the whole point of the gift and loan clause is that the state does not foster private business activity?
That's one of the things he said. He also said that there might actually be a legitimate public purpose here.
Yes, he thought the majority was being too restrictive in People v. Westchester, but he said even he, who was being generous to the state, was saying the whole point was you can't foster private economic activity. No. Isn't that exactly what you're saying that you're doing here?
The Agriculture Department grants were not made to individual entrepreneurs. They were made to promote.
Would they be unconstitutional if they were?
I think there would be a considerably more difficult question if they were. They're not, and this case has to be taken on.
How many people have to get together in a trade association to get the money then? If you get 3 people and call yourself a trade association, do you get the money?
No, the promotion here is of New York apples, and it's of New York wine. This is like the I Love New York campaign. And that is clear on the face of...
Do we know that none of these people have any New York competitors? Then what about the New York pear growers? They might not be thrilled to have the apple growers getting taxpayer money.
Well, I think there'd be no objection to the New York pear growers on precisely the same principle. I think there are also grants for the onion growers.
Isn't that the problem? Sure. Everybody can get money. That's how the taxpayers run out of money.
It's like promoting New York tourism. It is promoting the interest of the state of New York. It is not, these grants are not promoting the interests of an individual entrepreneur. They are promoting the New York economy.
Are they all doing that?
The agriculture grants?
The only reason I ask is I think of the wineries, and there's wineries in Niagara County and there's wineries in the Finger Lakes, and it seems like everybody knows about the wineries in the Finger Lakes because they're on TV, and the ones in Niagara County aren't. I hate to sound like a legislator.
I'd like to just say that this is a challenge. This complaint should be taken on its face as a challenge to a practice, not as a challenge to particular grants. That would be a different case. And I'd also like to say that these are utterly unlike, all of these grants are utterly unlike the railroad transactions that led to these gift and loan prohibitions for 2 reasons. One, the railroads got direct transfers from the state. They didn't get grants through public authorities with the controls that entails. And 2, the railroads got transfers of credit. When the state issued bonds, and that was what was involved in Westchester County, too, that's very different. When the state guaranteed railroad bonds, the state had an obligation to the creditors that didn't disappear.
Are you saying it would be okay under the gift clause to give the railroads cash?
No, I'm not saying it would be okay to give the railroads cash. I am saying that the purpose of that the cash analysis would have to be, if they were given cash in exchange for a commitment to perform particular acts that were a public service, and the cash would be taken back.
The act that you say is a public service is promotion of their own goods.
Well, it's a promotion of a state purpose. Suppose the state wants the railroad to be in one particular place and not another.
How is that not fostering private business activity?
The fact that it does foster private business activity doesn't defeat it if it also fosters public activity. When the state contracts with somebody to do something, obviously the contractor's business is fostered. He wouldn't engage in the contract otherwise.
Is there no difference between giving someone money in exchange for something? So I give you $1, you give me an apple. Saying I give you $1 so that you can go and advertise your apples and bring revenue into the state of New York. You see no difference between the two?
I didn't say I see no difference, but I think they are both on the other side of the line from a gift because they can be taken back.
So you said what I just described. Forget about whether it's to a trade association. If it's to one apple grower, the state can do it consistent with the gift and loan clause?
Well, if one apple grower were doing something of public benefit, if one apple grower were advertising for New York apples, yes. If the one apple grower were advertising for Jones Apple Orchard, I think that would be a different.
Can I just ask you about the burden of proof here? You said earlier that the presumption of constitutionality applies to legislative action. So the other side would have to prove that it's unconstitutional beyond a reasonable doubt. And am I correct?
Well, they'd have to prove that it's unconstitutional. I'm not sure what the standard would be. But I think the point is that this is the sort of thing that this Court decides and can and should decide as a matter of law. The Murphy case about a parking authority was decided.
Why don't you pick it up at rebuttal?
Yes.
Thanks, Counsel. Counsel, you want any rebuttal with your 5 minutes?
No, I'll use my time now. Thank you.
You'll leave the rebuttal to, okay.
General Underwood. May it please the Court, my name is Harold Islin, representing Global Foundries. What
are you getting from the State, Counsel?
Well, that's a good question, because what we are getting here is a grant pursuant to a grant disbursement agreement from ESDC.
From notes and bonds, right?
All from bonds financed through ESDC.
And how much money is involved?
Approximately $650 million.
But why is this okay? I know it has to do with chip manufacturing, but why is this legal for the State to give you those proceeds?
Well, I want to go back to the line question that came up, because I do think the line in this case can be drawn at funds that are provided by ESDC to a party. I think
so ESDC is always okay?
I believe it is. I believe it is. And the reason is I understand the questions about.
Is it because it's predominantly public? Is it because it's not through the State directly? What's the reason?
Yeah, it's because ESDC funds are not State funds.
Not State funds. Okay.
This Court has found that, and I don't.
Is that the only defense you have? I mean, that is, if this were done directly by the State, would it clearly be bad?
No, I don't, because I think the issues that the State has raised, that this is not a gift, is important. In our case,
but it's given to you, I mean, this is given to Global Foundries U.S. You're not a trade association, are you?
No, we are not a trade association.
So
these are ESDC funds given directly to us, but
and what are you doing in exchange for that?
We are investing over $7 billion in private capital and guaranteeing to the State well over 1,000 jobs, all sorts of other economic developments.
But this is not a charity. You're doing it to make money, right?
Yes. No question. But
say you weren't doing those investments, could they still give you the money? As long as they're giving it to you, it's not the State, is that okay, even if you weren't making this investment?
I think ESDC has the constitutional authority to make funds available under any circumstances.
Period.
So let's assume you got to the end of your fiscal year, and the year before you were making $10 million, and this year looks like you're going to lose. The ESDC could say, well, why don't you give us the bill for the difference between your losses and $10 million, and we'll write you a check, and then you'll be the same as you were the year before. Would that be okay?
Well, that goes to the issue. That goes to the issue of whether ESDC has the authority to do that in the first place. So again, we're not looking at ESDC's oversight in a vacuum.
Well, no, I'm just asking if you said once it leaves the State coffers and goes into ESDC's, that they can pretty much do with it what they wish.
No, they cannot do with it what they wish, because they're constrained by statutes and by their fiduciary duty.
Right.
They're not constrained by the gift and loan provision, but they are constrained.
So what you're saying is that ESDC can make a bad investment that doesn't promote economic development in New York, but that's a different issue.
That's a different issue.
If they have the right to give you the money, and if they're not doing their job.
Correct, because the gift and loan provision does not prohibit the State doing something that someone might argue is unwise.
Well, do you have a contract with?
Yes, we do. We have a grant disbursement.
So if you violate or don't perform under that contract, is there some action that the development court can take?
The State has extensive remedies, The State has extensive remedies, including the right to claw back the funding that ESDC has provided pursuant to that agreement, along with numerous other remedies that ESDC preserved for itself, which goes to the point of, are they doing something indirectly?
Does fiscal oversight remain with the State? Does fiscal oversight over your expenditures?
ESDC has oversight, and there is additional oversight through various statutory provisions, including with the controller and other
Do you see any problem, to go back to Apple's only, we'll use computers this time, if you got somebody who's working on computers in their garage and they want to come up with a new idea for computers, and they may or may not be successful, but if the state of New York through the ESDC says we're going to give $600 million to your competitor because they're going to bring in some jobs, doesn't they have a right to say this isn't what the state of New York is supposed to be doing?
Well, I don't think they have a right under the gift and loan provision. Again, I think there are various remedies available to them if the funding goes through ESDC. But do they have the right to, under the gift and loan provision, particularly as a private party? And I do want to touch on standing, so I'm glad you asked that question before my time runs out. Well, simply that as a recipient of bond proceeds through ESDC, that activity is expressly carved out of Section 123B of the state finance law, which does not accord standing to a private party to challenge the issuance of bonds. So at least in our case, and to the extent that ESDC funds are not state funds, there is no standing for a private party to attack.
Okay.
Thank you.
Counsel.
May it please the Court, I'm James Ostrowski, and I represent the 50 taxpayers in the case.
Counsel, what about this? Let's stick with ESDC for a while. They say as long as it goes through ESDC, there's really doesn't matter what they do particularly, that it's not subject to challenge. They may be making unwise decisions, but it's not subject to challenge. Why isn't it okay as long as it's not directly state money?
It's a matter of simple logic, Your Honor. If you're going to say that A can't give money to B, you must say that A can't give money to C to give it to B.
So
it's just a matter of legal logic.
You'd latch on to the directly versus indirectly argument?
Yes.
You can't do indirectly what you can't do directly.
It's a matter of logic because it's inherent in the rule that you can't do it indirectly. Otherwise, the rule doesn't exist. Also, the Constitution has the term in aid of.
Right.
And that's another textual.
What about all the case law where you had these very arguments raised, and the bottom line is that while you can't do indirectly what you can't do directly, the code often says, or usually says, yeah, but it's okay in this case.
Well,
why does that happen?
None of those
if it's
cases,
so logical.
None of those cases are directly on point. The truth is, and this goes to some of the questions that were asked, the voters rejected this in 1967, and they also rejected it in 1846 and 1874. And somebody came up with the idea of the Urban Development Corporation conveniently in 1968. This has never been challenged. It's not easy to launch a challenge of this nature.
So you don't think we have to upset any precedents to find for you?
Absolutely not.
What about Murphy v. Erie?
Not a problem at all, Your Honor.
Didn't the court somewhat soften this and say you can look at the public purpose?
They really didn't, because that was a lease case under a different clause that had to do with property. Then the government in that instance was getting $63 million. They were getting managerial help, which they didn't have to pay for to manage their stadium, and the public in Erie County in western New York was getting an opportunity to go to a football game or a concert. That's the degree of public benefit in that case was far greater than giving gigantic grants to a couple multinational corporations.
Well, let me just ask you something.
Westchester is still good precedent. I'm sorry.
So what does the state of New York, whether state officials or public authorities, how do they address the fact that the manufacturing sector in New York has been and continues to erode, and they want to compete with these other states and nations to bring these new high-tech industries in?
Cut taxes. We have the most expensive government in the continental United States. Our taxes are significantly higher than Ohio's and Pennsylvania, our nearest neighbor.
That may be part of the incentive packages, but that's it? That's all they can do to compete?
Well, we're happy to argue policy. That's why we have brilliant economists ready to go. But this policy's been failing since 1968. The New York economy's in the tank.
Well, I mean, is maybe, I mean, you say the policy's failing. Undoubtedly, they're going to say, oh, no, the policy's a brilliant success. But isn't your point really that the Constitution made that choice?
Maybe they don't live in upstate New York, but it's correct that all the policy decisions here were made, and they deride the fact that I'm citing 19th century authorities. That's when the Constitution was passed, 1846, 1874. Policy decisions were made at the convention that you can't rob from Peter.
Your argument is the Constitution is the Constitution.
The Constitution
that's what the plain language says.
Constitution is the Constitution, and from a policy point of view, and we'd love to argue this in the trial court, we would be much better off without these subs. These would have a lower tax rate. We wouldn't have capital decisions being based on political donations.
One of the reasons for this, and a lot of people complain about government and say they don't know what they're doing. And what government does, in this instance, as I understand it, is that we don't know about development. We don't know how to do it. We don't know who to call. We don't know what. So we're going to form a separate corporation, and we're going to fund it, and we're going to give experts that job to go out and find out what can be done and who can do it in terms of development, economic development in our state. What is wrong with that?
Because the politicians are naming the governor appoints the authority, and these. But
that's a political argument. In theory, in theory, they could do that, right? Say, you know, we want to put on a panel of experts to advise us and to act in our place instead on economic development issues.
But the people who don't know anything, obviously the politicians, are appointing other people to do something they don't know how to do. That's failed for 40 years. And the people who in these authorities are bureaucrats. They're not investment bankers.
But is it unconstitutional?
They don't know how to allocate capital.
Is it unconstitutional?
It's unconstitutional because Judge Smith was right. In response to the question, I think is the first time in the entire case that any of the defendants admitted what the purpose of the gift clause was, to end the fostering of private enterprise. It's unconstitutional.
So are the primary functions of all these public authorities that engage in the disbursement of capital, they're all engaged in unconstitutional activities?
Yes, they're based.
And the Public Authorities Control Board that oversees them?
Well, the control board is overseeing a money laundering operation. They can't change that fact. It's obvious from the papers that the legislature is appropriating money for a certain company, and that's going to be funneled through the Urban Development Corporation simply as an end run around the Constitution, which is never these clauses have been modified about 10 times, but they've never taken out the gift clause. And now they're coming in and they're asking for a judicial nullification.
There are quite a few exceptions to the gift clause, aren't there?
There are exceptions, and those.
Does any of them apply here and to any of these things?
They don't apply in any way that's helpful to the defendants, but they show that exceptions have been carved out to allow a public authority to do this and that, which by the expression of that excludes other examples. There's an economic development. I think that's subsection 3 or possibly 2. They're allowed to engage in lending for economic development, which shows that they had to carve out an exception to that. So none of the exceptions are helpful to the defendant's case.
Is bonding by the public authorities also embraced by your same position? For instance, when the dormitory authority or the UDC goes out and bonds in order to do hospital expansion in a private hospital, that's also a violation of the provision?
No, they're allowed to do that. That's one of the exceptions, health and welfare. Look, my clients, and I can say some of them are in the courtroom, I could speak for them. They don't care what the authority does with its own money. I didn't hear anything from counsel about how these bonds are being funded. If the authority is going to come up with some way of funding it themselves that's not coming out of my client's pockets, we probably won't care about it after discovery.
You're saying that if they borrow, if an authority issues bonds secured by the authority's own revenue, it can do whatever it wants with the money?
We don't know we don't know. If they're not getting the money from the state taxpayer or the state or the legislature, they may be able to do that.
So that if the authority owns a very lucrative bridge or tunnel, which makes a profit, it can use those profits to subsidize whatever pet causes it wants?
The government is allowed to own enterprises in New York State. That's not a problem.
That's not your lawsuit, no.
That's not our lawsuit, Your Honor. Let me just address the issue of consideration. Back when everything they're saying on consideration, IBM's promising to create so many jobs, this was all done by the railroads. It's cited in the brief, the examples of the subsidies pre-1874. We give them such and such on the condition that they build a canal or they build a railroad. Deals with some sort of arguable consideration, albeit very strange form of consideration, were made illegal in 1874. The fact that there's some sort of arguable and very strange metaphysical form of consideration not flowing to the government as in Murphy, but flowing, it's out in the ether. Even if that's true, and we will vigorously contest that and deny that because we don't believe there's any benefit at all, we believe it's a zero-sum game, that doesn't get around the constitutional ban because the constitutional ban, the purpose shown by the legislative history, which only our side of the case seems to be that interested in,
You would agree
precisely what made it legal.
You would agree that an exchange for value is not prohibited.
Sure.
I mean, the state bought me this pen. They're allowed to do that and pay for it.
Absolutely. But there's
when they don't get the pen back, that you have a problem?
Nobody's going to confuse the state hiring a janitorial service to take care of their buildings with a subsidy. I think we all know what the subsidies are. They're pretty obvious.
If I could ask you, what's the remedy you're looking for in this suit?
An injunction?
What happens down the road if you're successful?
We want an injunction against any illegal spending, and we want a declaratory judgment.
A lot of these projects are underway. I mean, I think your action involves the nanotech project by SUNY Albany. Those buildings, that's a very successful incubator project, and there's other buildings under construction there. So what happens if you're successful? They have to stop that construction?
We only sued a couple of companies, Your Honor. It's not our intention to go out and try to recover all sorts of money that was previously committed. I'm not saying we won't do that with the named defendants in the named projects, but our primary concern is going forward. We want this illegal practice to stop. And how much money is recouped if we win this case perhaps is up to the Attorney General's office, not the 50 taxpayers.
Anything else, Counsel?
Just want to point out, Your Honor, I think there's the three leading cases, nothing exactly on point, but the appellate division decision was correct on all 3 points. They relied on Westchester County, which is the case that's closest to this one. And by the way, Judge Andrews did find a public purpose in that case. The state's brief and reply brief are a little confusing on that. Glad to see in the dissent that Judge Cardoza agreed with our position and also Judge Andrews. That case involved vastly greater benefits to the public. World War I veterans coming back from a nasty war and their families, but it wasn't enough to override the Constitution. The Smith versus Smythe case is very interesting. 35% of Bronxville would have benefited from the street paving, and probably most of the village, if you factor in the people who used it, not enough to get around the prohibition on gifts. And the Murphy case, again, frankly, if you look at the Murphy case, it's not even assuming it applies because it's a totally different factual context. The fact that the county was to get a huge amount of money back, a huge amount of free managerial services that they wouldn't have to pay for, and opening the stadium up to virtually everybody in Western New York or even statewide as a direct beneficiary. The only direct beneficiary of these huge grants to the multinational corporations are the multinational corporations. So the legislative history, the purpose, the text, and all of the relevant cases from this court support the appellate division's decision, and we would ask you to affirm.
Okay, thanks, counsel. Counsel, rebuttal?
Just a few points. The suggestion that somehow the words "in aid of" in the Constitution sweep in a wide variety of things, I think is mistaken. The history that led to that phrase is that sometimes what the state was doing was actual work, surveying and spending money in aid of the railroads.
But if you look at the plain meaning, it seems to be, on its face, mean what it says, right?
It does mean what it says. The question is, what exactly does it say? And I don't think it means that anything that in any way helps private corporations. It can't possibly be that.
But how can it be not okay to to subsidize an activity that benefits the railroad, but perfectly okay to hand cash money to an intermediary who hands it to the railroad?
Because the gift clause originated in 1846 and was dealing with one set of concerns. In 1938, there was another constitutional moment when the Constitution recognized public authorities, and by the Constitution and statutes and subsequent decisions exempted them from.
Wouldn't you, if they wanted to say it's okay to give money through the intermediary of a public authority, wouldn't you expect them to say that?
No, I think in the context of what was going on at that time and subsequently, the courts essentially recognized that, and that is exactly what was going on.
The 38 Constitution did retain the language we're concerned with here pretty much intact.
It retained the language, and it created it recognized public authorities and put limited control or supervision over them and so forth. This was a new phenomenon that was superimposed on the regime that was created in 1846.
Were they all self-funding authorities?
They were not. Some were self-funding. They began as self-funding authorities. They were not all ultimately self-funding. The public authorities have evolved just like everything else, just like us. Another thing I want to say is that the notion that there should be grant by grant or transaction by transaction adjudication completely undermines the viability of any economic development program, because few companies would participate if they knew that halfway into the project there could be review. Presumably that's why plaintiffs have suggested that though their complaint asks for the money back, they might not really be asking for the money back after all. And Murphy makes it clear that we don't invite the court to measure the degree, to quantify the public benefit and trade it off against the private benefit. It says that
doesn't People v. Westchester make it clear that no amount of public benefit in itself will justify a gift or loan at the state's credit?
Westchester involved no quid pro quo at all. There's a difference between something that simply is thought to have some general public benefit and something that asks.
What about the subsidies to the railroads? Did they involve a quid pro quo? Was you use quid pro quo?
There was no way to get the money back. A contract.
No, you subsidize a railroad, you get the money back the same way you get it subsidized.
They were subsidizing it by guaranteeing bonds. Once the bonds have been issued.
The railroads create all these jobs and generate all this revenue, just what he's doing.
I think the problem of credit was perceived by the Constitution drafters as a different problem. It involves irrevocable commitment of the state's funds for generations. It's difficult to unwind if there's non-performance. A transfer of money to purchase services under a contract or something like a contract does have the controls.
So giving cash to the railroads would have been fine?
Giving cash to the railroads under a contract in which the railroads agreed to do particular
agreed
things.
to advertise New York Railroad service.
Possibly. I mean, we're now developing a hypothetical that they would have to. It's possible that a contract with the railroads for cash transfer would have been acceptable. The evil at the beginning in 1846, it was only credit that was prohibited. The initial clause didn't prohibit cash transactions at all. So at that time,
that got changed, though.
Certainly, it got changed for a different reason. It got changed at the same time that the localities were added, and the debates were principally about giving money to charities. The two quite differently motivated provisions.
Thank you.